Muslim jurists refer to the earlier scriptures in terms of their legal content, and they call them laws of those who came before us. The laws of those who came before us are the body of rules ordained by Allah for the nations before the Muslim Ummah through revelation to their prophets and apostles. Muslim jurists have differed somewhat about the relationship of such laws with the Sharia, as well as about their binding force for the Muslims. Some maintain that this body of rules was abrogated by our Sharia, while others said that those parts that were not abrogated are binding on us. The types of earlier laws contained in this body of rules are the following. First are rules that have been repeated in the Quran or the Sunnah and have been made obligatory. These texts themselves provide the evidence about the binding nature of the laws, and we do not have to refer to the earlier scriptures. These laws are binding on us just as they were binding on the earlier nations. An example is fasting during Ramadan. Second are rules that have been described in the Quran or in the Sunnah but are considered abrogated. These are rules about carrion, blood, flesh of swine, and the like. Third come rules that are not mentioned in the Quran and the Sunnah but are found in the earlier scriptures. There is no dispute that these are not binding on us. And fourth are rules that are mentioned in the Quran and the Sunnah, but there is no evidence whether or not they are to be followed. The example given by some jurists under this heading is that of qisas, or retaliation. There is, however, ample evidence in the text that it is binding on us. This shows that the real sources for all such rules are the Quran and the Sunnah, and they become binding on the Muslims when these primary sources grant the authority. To elaborate on the basis for not accepting the rules in the earlier scriptures, Al-Sarakhsi makes the following statement. The most authentic statement in our view is that what is confirmed as an earlier law through the Book of Allah, or the elaboration by the Prophet, peace be upon him, becomes a law for us, unless it is abrogated. As for what is transmitted by the people of the book, or is understood by the Muslims from their scriptures, is not binding on us because of the established evidence that they altered their books. Their transmission is, therefore, not accepted on the assumption that what is transmitted is entirely changed.